Yeah.
Okay, very good. Good afternoon, everyone. I'm Stephanie Verdial. I'm the principal planner here at the Office of Planning and Development. With me today is our assistant planner, Alvina Snagach. She's going to be assisting with the chat questions and keeping us on track and on time. Today, like I said, we're going to be talking about Land Use Administrator 101. There are many job descriptions out there, many different titles that go along with being a land use administrator. But just for the purposes of this webinar today, I'm going to stick with the land use administrator title. So today I'm going to be reviewing, understanding that I started my municipal career as a planning technician and was a planning secretary to planning board, zoning board, conservation commission, historic district. So for about 10 or 11 years, I was the land use administrator. So some of what I'm going to talk about today is just some of my personal preference of what I worked with. But we're going to go through the different land use boards, what the RSA defines them as, the applicable laws for the applications and the committees that you work with, application types, some office management and meeting management kind of tips that, again, it's just from my own experience that I've used that have worked out well. And then moving into our Q&A towards the end. So again, like I said, there's a bunch of titles out there for all of us for what we do. You're a land use clerk, land use coordinator, land use secretary, planning and zoning clerk. One thing to remember is what I call this position is that you are the gatekeeper. You are the first point of contact that the public has with the land use department and with the land use boards. And so, as we all know and find out maybe under fire, just from experience, that you have to have a lot of ability to multitask, be organized, and again, be friendly. You're the gatekeeper. You're the ambassador to the department. A lot of times you're the ambassador to the town. So it's important to be friendly and organized and know how to multitask. And then also today I'm going to focus a little bit more on the land use administrator, just dealing with the land use boards. I do understand that some of these positions and some of these titles and part of your responsibilities can kind of roll into the building department, processing building permits can roll into the assessing department. And some of those, duties may be included in your title. But for today, I'm just going to, again, focus on pretty much just the planning and land use boards or planning and zoning boards and the land use boards. If you have any questions regarding building permit things or assessing things as part of your title, let me know, reach out to me and I can help you go through that. So, again, keeping in mind that you're the gatekeeper, part of your responsibilities, you perform highly technical and clerical duties while coordinating the functions of all the boards. Again, like I said, I was historic district, conservation, planning and zoning, any other subcommittee that came along. So multitasking is an understatement. And again, we're serving as the primary contact for the town. You consider yourself kind of an ambassador. A friendly smile at the counter goes a long way, or a friendly voice as to people, wanting to come to town, wanting to do business in town, want to build a house, want to build a shed, want to learn about the planning board process. You are the gatekeeper. So just make sure that you're aware of that in your role. It is a highly, it's a busy role. It's a highly stressful role. You do need to have good communication skills. And again, any other kind of duty that would come along from the chair of your boards or from, any other town officials, you have the full plate, and it's hard to be, a good ambassador, but that's what we're all responsible for to do. So when we talk about you're responsible for the local land use boards, there's definitions, and we're going to review a bunch of definitions today and just kind of be clear as to, what the law says and how these definitions are applied. So what a land use board law, the law says about what a land use board is: the planning board, historic district commission, inspector of buildings, your building inspector, your code enforcement officer, the building court of appeals, zoning board of adjustment, or other board or commission as authorized by 673, which is established by your legislative body. Your legislative body is either your town meeting form of government or your city or town council form of government. And so when we look at, those are the main land use boards, again, by legislative vote, the legislative body may include the following to be a local land use board, which is your Heritage Commission, Historic District Commission, Agricultural Commission, and a Housing Commission. So if you have all of these, several of these, note that they are all land use boards. And all land use boards hold meetings, and they can also hold public hearings. So it's really important to understand the differences, the nuances between some of these definitions. And when you're dealing as being a land use administrator responsible for a lot of boards, a lot of committees, it's important to know the difference for these definitions. So what is a public meeting? What is a public hearing? So a public hearing is a meeting that's duly noticed and advertised in advance, open to the public, and it's either called by the town council, your planning board, your land use board, a commission of the town, and it's for the purpose of taking formal public comment, both in favor and opposition to a proposed action. So that is a public hearing. Your planning boards, your zoning boards have public hearings, right? Those are the most common ones, the most familiar ones. A public meeting is an informal meeting, hearing, or workshop of a municipal board, committee, commission, or governing body that the public may attend and provide input. So the differences between a meeting and a hearing also goes along the lines of different notifications. So, and we know we have public meetings and we have, public hearings. We also need to understand, what other types of laws are involved with your commissions and with your committees. And as your role as a land use administrator. So the first law that I used to kind of keep on as a checklist in my office, just as a reference guide, is called RSA 33A3. It's the disposition of municipal records. We'll review that in a minute, but it's the minimum guidelines of the law for how long you should be retaining materials and applications. Other laws that you could be involved with as your position as a land use administrator are the RSA 36, 3656, and 3657. Those laws have to deal with regional planning commissions. And if your planning board or your zoning board declares that an application is worthy of a development of regional impact, then you need to be aware of the RSAs that govern developments of regional impact. If you are staff to a conservation commission, you should be aware of RSA 36A, which governs conservation commissions. All of your land use boards and committees have meetings and hearings, so you should be aware of the basic requirements for RSA 91A, which is the Access to Governmental Records Act. And depending on what municipality or you are working for, you should be aware of the New Hampshire DES laws regarding the Shoreland Water Quality Protection Act. Those would be like wetlands permits, those types of things, which is RSA 483B. And the main RSAs for land use, for planning boards and for zoning boards are RSAs 672 to 679. So, going through the Disposition Records Act, again, I kept this in my office just kind of like as a reminder, as a question. This outlines how long you should be keeping all your materials. I did not highlight the building permits and things like that, current use applications. But again, these are the types of things that if there's a question about whether or not you can toss something when you're cleaning files or keep it for, permanent record keeping, then that's what you should, this is the list that you should be following. Pay particular attention to meeting minutes, where all notes and tape recordings are to be kept until approved at the following meeting. Once those minutes and the tapes are, once the minutes are approved, then all the tapes and materials can be destroyed. Any minutes of any board or any committee need to be kept permanently, as well as town meeting minutes, selectmen meetings minutes as well. Those minutes are to be kept permanently. Again, a few other laws that you may come in contact with the planning board or historic district for road layouts and scenic roads. Make sure that you're aware that those records need to be kept permanently. Again, part of what I found a little bit frustrating when I first started being a land use administrator is that you would go to a file and try to, research it or learn about it, or there's a new application and what's the history of this file, and the files were incomplete. I think, maybe some of us have run into that situation, and it's difficult to work with files that are incomplete, learning the history, what was approved, what wasn't approved. So I, met the intention of the law, as well as I would keep some information. Maybe I would keep an 11/17 plan and just some, brief information, so that when I looked at that file in 2 years, I could remember the history of it and what was approved, what wasn't approved, if there's any violations there. So I kind of, figured out my own system for file keeping and for filed retention. Again, work this out with your town attorney, work this out with whatever works best for you or for your chair. But as my experience and my opinion, I did find it helpful to have complete files. So there's a way that you can figure out what works for you without having, your files really overgrown. But again, finding that balance of keeping materials to learn the history, as well as not overburdening your files. So the first law that basically you need to deal with and understand the requirements is 91A. It's kind of the basic framework for all the noticing requirements. And again, we have to go through, definitions. So when you talk about any committee, any advisory committee of any council, that's what the RSA 91A would apply to, which is any committee, council, or commission whose primary purpose is to consider an issue or issues designated by the appointing authority. So the appointing authority could be town meeting, could be city council, board of selectmen, or the land use board. So any advisory committee could be a master plan committee, a old home day committee appointed by the board of selectmen. So any kind of committee falls under 91A. And when we talk about governmental records, that is any information created, accepted, or obtained by or on behalf of any public body. We'll review public body, public agency in a minute, but that's any information. That's a letter submitted by an abutter. That is any information submitted to the Board of Selectmen on something. Any information that comes across the counter that is submitted to the town in relation to a committee or in relation to an application or any reports, anything is public record. So if an applicant or a butter wants to come in and look at a file, they can look at the entire file. Everything that's submitted is public information. And if you have any questions, about what constitutes a governmental record or what's access, or obviously a town attorney-client privilege things apply. But if you have any questions about something you get in across the counter or something that is mailed in or something for an application, reach out to your town attorney. You'll hear me say that a lot throughout this presentation, but reach out to your town attorney for guidance about what constitutes public information that anybody has, the ability to see, or what's not. So, we just talked a little bit about what a public agency is and what a public body is. So a public agency is any agency, authority, department, or office of the state or any county, town, municipal corporation, any school unit, any charter school or public school political division. That's what a public agency is. And for planning and land use purposes, for what a public body is highlighted in 91A as any legislative body, board, commission, committee, agency, or authority of any town, municipal corporation, school district, or charter unit, and other political subdivision or committee, subcommittee, or subordinate body. So that is what a public body is, which includes any subcommittees, and includes any other land use boards. So back to, meeting, or talking about a meeting. So a meeting basically is the convening of a quorum of a public body. So that's basically what a meeting is. Understand that a meeting takes place either by telephone, in person, through electronic communication, and yes, you can have meetings via email, something we'll talk about as well. And so having a meeting, whatever a quorum is convening, either electronically or in person, so all the participating members can communicate with each other, because you can still do that via email, and for the purpose of discussing or acting upon matters of which they have supervision or control over. So a meeting would be, the planning board meeting. So that's would be considered a meeting. You've got a quorum together. They have, a charge for their purpose of reviewing applications. So also there are non-meetings. So a non-meeting is also one that is a chance encounter with a board member. If two board members run into each other at a grocery store, that is not a meeting. If they're at Old Home Day, that is not a meeting. Also not a meeting is meeting with your legal counsel. So I would strongly recommend that you review, if your town council is going to come in and talk to your planning board, make sure that you understand how that meeting should be. It still has to be advertised as a meeting. It's just advertised as a non-meeting. It's very, very confusing. But please make sure that you're speaking with your town attorney regarding the noticing for a non-meeting. According to the law, they define circulation, which is circulation of draft documents, which can include minutes and notices of decision, which, when finalized, are intended to formalize decisions previously made at a meeting. So if you are circulating minutes and to all the board members, and one or two of them respond and chime in, or someone responds and makes an edit, you are now having an unnoticed meeting, which is in violation of 91A. So please make sure that you are reviewing with your town attorney, with your board chairs, with your board members, what your policies and procedures are for communicating, using email to distribute minutes, to distribute any other information, and what the do's and don'ts are of communicating in an email. All meetings, whether they're held in person or by telephone or electronic communication, shall be open to the public. It's important to understand. You cannot prevent anyone from going to a public meeting. Any person shall be permitted to reuse recording devices. If I want to come into the Old Home Day meeting and I want to record what they say, I am allowed. I can sit down, I can record, I can take notes, and that is all well within RSA 91A. Minutes of all meetings, including non-public, for a general framework for what meetings should include. They should include the name of the members present, the persons who have appeared before the public bodies, people who were in attendance, a brief description of what the subject matter was that was discussed, and any final decisions, and the names and the members who made the motions, and all of those should be recorded in the minutes. Now, there's a fine line between going word for word, verbatim minutes, and then, just saying everybody met, talked about Old Home Day, made a motion to adjourn, meeting over. Okay, that you may need a little bit more information than that, but you do not have to go, verbatim. Like I said, just make sure, think of it, if you had to look up a file in 5 years from now and you're looking at minutes or you're looking at a notice of decision, would you understand what happened? And would you understand what the result was of that meeting? So find that comfort level for you. Again, work with your chairs, work with your town attorney about how you're meeting the requirements of 91A, and then how you're also, preserving a complete file, and a file that's helpful for future references and for history purposes. So continuing with 91A, this is, 91A again is pretty much probably the most important one to make sure that you're in compliance with, as far as access to public records, allowing the public in, and minutes. Minutes shall be promptly recorded, meaning the draft minutes. They need to be completed and finished. Open to public inspection, whether that's on the website, or whether that's in the office, not more than 5 business days after the meeting. So fortunately, most land use boards meet within, during the week, where there's several days where you could get it done, in the office. But if it's business days, make sure that you're reviewing exactly how many days that is with your town attorney and making sure that your chairs are aware of it. If you meet on a Wednesday, then you've got Thursday, Friday, Monday, Tuesday, Wednesday to get the minutes done. Now, I've had a question come up to me before about, well, the office is closed on Friday, and does that count, or the office is closed on Monday, and does that count whether or not to get your minutes done? I would say, yes, it does. That's still, even though you guys are closed, it's still a business day, right? There's still mail, there's still things going on. So I would interpret that is to make sure that you are taking into account, if you are closed one day a week, that to make sure that you are including that as the 5 business days. Of course, your town attorney should make the final interpretation of that, but it's really important because if you're not following 91A, and if you're not following or complying with 91A for when minutes and decisions are completed, then someone can appeal that decision, and then you're into a court scenario. Okay, so make sure that if your office is closed any days of the week, that you're working that out with your town attorney to make sure that when those meeting minutes have to be completed by, and the decisions have to be completed by. So when you are having a meeting, the posting of it is at least in 2 public places. And again, when we talk about having a meeting, having a public hearing, we have to be really specific, because for posting purposes, number one, because have a meeting, you only need a minimum of a 24-hour notice, which cannot be on a Sunday or a holiday. So if you're having a meeting on a Monday, unless it's an emergency, you can't post that meeting on a Sunday. You'd have to post it on a Friday at the earliest. To have a public hearing, we all know that you need a 10-day in advance. So it's really important that when you're talking to the public, that when you're talking to the boards, when you're trying to schedule all these things, whether or not you're going to be having a meeting or a public hearing, so that you don't run into legal issues about notice requirements. So also for posting, 2 appropriate places, one place can be on the town's website, or it shall be in a newspaper of general circulation. So again, make sure that you know what type of meeting or hearing that you're having, and make sure that you're clear about what your posting requirements are. You should be also making sure that your rules of procedure for your boards also have provisions that comply with 91A and other RSAs that we'll talk about. But you'll hear me say that a few times as well, is to make sure that your rules of procedure for your land use boards at least meet the minimum standards of the RSAs. You're not missing anything of what's required in the RSAs. So moving into some of the land use RSAs, so 672, particularly and through 676 is what we're dealing with land use boards. And there is, again, a little bit of a crossover. You'll see that you have to meet this of RSA 676, blah, 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 as well as having to meet RSA 91A. That's why it's important to understand what RSAs that you're meeting when you're dealing with your land use applications. So when we talk about definitions, 672.2 talks about a lot of definitions for land use boards and processes. In particular, defines what an abutter is. And what I've highlighted in the definition is just to make sure, again, we have to be really particular, and we have to be really careful, well organized, in order to make sure that we're doing our noticing properly. Because if we're missing a notification, if a condominium application comes in and I didn't follow 672 3 for noticing of what a condominium ownership is, then I've thrown that whole case into a mess, right? Someone wasn't noticed, you have to rehear it. So it's really important that you understand that there are nuances when it comes to noticing condominium associations form of ownership, as well as manufactured housing park. And so Other terms of RSA 673, it's kind of the governance of local land use boards for planning and zoning. Again, these are the types of things that should be in your rules of procedure, how often to have meetings, what the board organization is, board member terms, all of these things are spelled out in the RSAs. So it's prudent for you to make sure that board's rules of procedure are matching the RSAs. And we look at 673.17, and we understand that when it says each local land use board shall hold its meetings and maintain its records in accordance with 91A2. So again, this includes all land use boards and all committee meetings. And note that to comply with 91A2, public meetings only need an agenda. So again, we're making sure that what type of meeting you're having, what type of notice to the public. So moving on to 675, this deals with enforcement procedures and regulation adoption. So this is kind of the, excuse me, the groundwork for your noticing requirements, for your regulations, and for your zoning amendment process. 675.1 goes through the general requirements of notification for adoption. 675.2 and 3 review the different notification times and requirements for city councils and town council forms of government, as well as for town meeting form of government. 676.5 refers to the process to amend and adopt the subdivision, site plan, master plan, excavation regs, driveway regs, all those types of land use regulations. Paying attention to 675.6, making sure that you're following that needs a public hearing. Because public hearing, you're soliciting the public, you're proposing a specific item, you're proposing an amendment change. So anything to amend or adopt regulations needs a public hearing. And 675.7 is, again, how those amendments all for land use regulations all have to go through the process. So make sure that you're following those processes, the nuances between city councils, town meeting form of government, and that your adoption and notice requirements for those regulations, you're meeting them through the RSAs. 676 deals with administration and enforcement procedures. 676.1, 2, 3, and 4 deal with your rules of procedure. Okay, we have to make sure that your own personal rules of procedure for your board match, at least at the minimum, the rules of procedure in 676.1. Joint meetings, again, something in your rules of procedure. If the planning and zoning board are going to meet, who's in charge of what's the order, all of those things should be in your rules of procedure, as well as meeting the RSA requirements. With decisions, which includes minutes, spells out when they need to be done. And again, consult with your town attorney. These types of things should be in your rules of procedure. On third-party review, I'm a big fan of third-party review. So if you don't have third-party review already, if you're not really utilizing it, familiarize yourself with it. Consult with your town attorney. It should be something that is in your application or in your procedures or in your site plan or subdivision regulations. So this is basically for planning board, continuing on with like the administration and enforcement for land use boards. So the board's procedure on the plats, which is, part of the notification process. I've highlighted here that when you're working with noticing the abutters, which is, holders of conservation, preservation easements, it's important to understand that with planning boards, you need to include the names and the addresses of any professional who worked on that plan. So any engineer, landscape architect, wetland scientist, soil scientist, surveyor, they should all be included on the notification that their plans are being reviewed at a meeting. So make sure that they are included on your abutters list. And so we'll move into the zoning board of adjustment and some of what their RSAs are and some of what their applications are that we all need to keep straight, and what we're responsible to take care of under the zoning board. So 676.5 describes and constitutes what is an appeal to the zoning board. And we have to have some definitions, right? As usual, when we have these types of things to figure out, because it's all part of the application process, is identifying these definitions. So when you have an appeal to the zoning board, is it concerning any matter within the board's powers as set forth in 674.33, it's governs ZBA, may be taken by any person aggrieved or by any officer, department, board, or bureau of the municipality affected by the decision of the administrative officer. So the administrative officer is defined in the RSA as any official or board in that municipality who is responsible for issuing permits and certificates under the ordinance, enforcing the ordinance. That can include the building inspector, the board of selectmen, any other official or board with a responsibility. And so there, you could say that you would lump in the planner with that as well, because the planner would have enforcing, making interpretations, issuing permits, that type of thing. So the planner could also fall under, based on interpretations, as one as the administrative officer. And so these administrative officers make administrative decisions. So any decision involving the construction, interpretation, or application of the terms of the ordinance is considered a decision of an administrative officer. So a basic zoning interpretation, which can be appealed, is a decision of an administrative officer. And such decision, the law says, such an appeal of that decision shall be taken within a reasonable time as provided by the rules of procedure of the board. So again, I can't stress enough, I'm going to keep saying it over and over again, that you need to speak with your town attorney on having complete rules of procedure, going into the nuances of the RSAs, and figuring out what is reasonable. What's a reasonable time? Well, 15 days may be reasonable to me, but 30 days is reasonable to the appellant. So we're already at an impasse as to what is reasonable, right? So having a reasonable time, 30 days after the decision, 15 days after the decision, work that out with your town attorney. So there's no confusion for the board. There's no confusion for the appellant. There's no extra court cases because we're arguing over what reasonable is, and let the court be the ones that make up the decision as to whether or not what's reasonable. So work with your town attorney and figure these things out. It may sound insignificant, but it's really important to have them straightened out, especially for when there are appeals of applications or your decisions. The process should be pretty clear to understand. So again, it's important to understand and review this because it can get confusing. So while you have decisions made by administrative officers with interpreting the zoning ordinance, the planning board can also make interpretations of the zoning ordinance. And to make it even a little bit more confusing, they have a different process than if it was appealing of an administrative decision. So please, again, review these types of decisions and type of interpretations that make up appeals with your town attorney to make sure that you and the board understand the processes. And so we're working on ZBA applications, understanding what type of appeals and what the requirements are for ZBA and the ZBA type applications. So appeals to the zoning board are considered all types of applications to the zoning board of adjustment. So 676.5.14 describes the administration issues with the zoning board of adjustment. Just like the planning board, they're allowed to impose fees, administration fees. The ZBA is also allowed to utilize third-party review, which again, I'm a big fan of third-party review. I think that every board should be using third-party review when in doubt, or when it's a big project, or if you don't have town staff to do it, or RPCs are unable to do it. If it's something very specialized, I would absolutely encourage you to use third-party review. And the nuance with third-party review when it comes to applying it to the zoning board of adjustment is that by obtaining the third-party review and consultation during the review process, provided that the review and consultation does not substantially replicate a review and consultation obtained by the planning board. So again, work with your town attorney, work with your board chairs, because there could be a scenario where I'm a car wash, I guess, and I need a special exception, and I also need a site plan review. So special exception has criteria as outlined in the zoning ordinance, and one of those criteria could be whether or not my car wash is going to impact, town facilities, water runoff, wastewater, water supply. So the ZBA wants to get a third-party review to review that particular issue for the particular criteria of a special exception. But then when I get to the planning board and the planning board has concerns about traffic or concerns about, impervious surfaces or whatever else, they can utilize the engineer to address the traffic issues. You just can't have it be redundant. So those are, again, these are things that we need to kind of understand when we're working with a lot of these applications, what the law says to make sure that we're meeting them, because most appeals and most court cases can be administratively produced. So we want to make sure that we're cutting off as much as we can that opportunity for a slip up and have a case be appealed. So again, once an appeal is filed with the ZBA, this section outlines what happens to it. Again, if you have an appeal, my decision of, I'm a planner, I decided that, a train station can be built there. Well, the people around the train station, appeal my decision. Well, everything stops. You cannot move forward. They can't get a building permit. They can't continue construction or whatever the case is. Everything stops when an appeal is filed. So again, if you want to have that in your rules of procedure, can put it on the list of something else to talk to your town attorney about what does happen when an appeal is filed. So this is the 676-7 is the public notice for for public hearings, because that's what ZBAs mostly have, are public hearings. And note, so if we know the differences between noticing requirements between ZBA and planning board, it's really important because, again, administrative issues can be, the reason why something is appealed. So note that the date, time, and place of the hearing and such notice shall be given no less than 5 days before the date fixed for the hearing of the appeal. The board shall hear all abutters, holders of conservation, preservation, agricultural restrictions, desiring to submit testimony, and all non-abutters who can demonstrate that they affected directly by the proposal under consideration. A little bit different than planning board notifications, right? A little bit more in the planning board world. You'd have to kind of prove your standing, or at least explain to the board, listen, I'm an abutter, but I'm one house away from a notice to butter. And this traffic from the car wash is still going to affect me. So the board or a judge could grant you, someone who has standing. ZBA, again, you need to understand the nuances a little bit different. If I just show up to a ZBA meeting and I wasn't noticed, I can make an argument right there that I can be, I can provide testimony for this application because as the ZBA seems appropriate, if I'm one house away from a notice to butter. And again, a public notice for the ZBA is different than for the planning board. ZBA's public notice of the hearing shall be placed in a newspaper of general circulation and in not less than 5 days before the hearing. So again, review with your town attorney and see what type of noticing requirements, your rules of procedure, and what should be in place for make sure that you're meeting that with zoning board of adjustment. So 676.7 again outlines the requirements for noticing for the ZBA. And just basically the same thing with the planning board. The cost of the notice is, the applicant is responsible for that. And what I did when I was a land use administrator and why I kind of stuck 676.4 into the slide is because for noticing requirement, not necessarily the time frame I would take from the planning board notice for public hearing things. It's that I would utilize the every architect, engineer, soil scientist, professional courtesy, maybe even a legal courtesy. The law doesn't specify that for ZBA, but I went above and beyond and I did it anyway. Because if I'm an applicant and my septic designer made me a plan, and then I go to the zoning board of adjustment because I want to have an ADU, but I may have altered that plan a little bit. Well, that plan has a professional seal on it, and it should not be altered. So that's my little caveat there. You can check with your town attorney if you want, but for any type of application, I consider in a butter as highlighted by 676.4. And I would notice professional people, even if it was for a ZBA application. So a few kinds of appeals, and any application to the zoning board of adjustment is known as appeals. So we'll go through what a motion for a rehearing is. And that is basically a request for the board to reconsider a decision. And it does include the ZBA reconsidering their own decision. That includes another municipal land use board challenging a ZBA decision. So I've had an experience where the ZBA has approved an application. Next day they wake up and they said, "Oh, we forgot about such and such section of the ordinance," or, "Oh, wait a minute, I think we just made a mistake." The ZBA can challenge their own decision. Make sure you're working all this out with your town attorney, but it's not against the law for a board to, that's what designed for. The laws allow a relief valve, right? That's what zoning variances are for, allow that relief. So if a board makes a mistake, which is entirely possible and entirely acceptable for a board to make a mistake, this is the avenue that they would take to try to remedy that. And to understand when the appeal period starts, it is the day following the meeting. So if the ZBA meets on a Monday and they make a decision, then that Tuesday morning, the next day, or 12:01, if you want to get really technical, that's when the appeal period starts. So it's 30 days that you have to make that appeal, and it's the day after the meeting. Again, things that should be spelled out in your rules of procedure so that the board and the public and staff understand what the appeal period is. So if you receive a motion for rehearing and it's not a public meeting. So I am submitting a motion for rehearing from that car wash. So I go in the next day and I fill out a motion for rehearing information. I say why, you didn't take into account that, I don't know, it's in a wetland, or it's in a stormwater protection zone, or something, new information that was not available to the board. So that's what I'm basing my motion for a rehearing. Okay. So I just submit that information. That's for the board to consider at a public meeting. It's not a public hearing. The board is going to look at my application to submit for a motion for a rehearing, and they're going to say either yes or no. Yes, we agree with this motion for rehearing. Oh, we made a mistake. Yeah, we have to do this. Or no, we're solid with our decision. We're going to move on. So there's no public input. It's an agenda item. Again, review with your town attorney. That's the way that I've handled them, and how I've advised them to be handled. Because the public hearing doesn't come until the ZBA grants that motion. So they're going to say, yes, we're going to rehear this car wash application. We're going to rehear it on August 20th at 7 p.m. Then that is when the application moves forward into a more formal appeal where, okay, now we have to notice the public, we have to notice the abutters, and we have to go through that process. So again, make sure that you're understanding the applications and what their noticing practices are and what their regulations are for noticing. So more powers of the zoning board of adjustment, again, understanding more applications that fall under the ZBA. We just went through administrative appeals, understand variances, understand special exceptions, and the laws that apply to those applications, those types of criteria. One application for ZBA that is not very popular. They're pretty rare. But you still need to understand what the law pertains to for them. Are equitable waiver of dimensional requirements. There's also other laws that are other applications that the ZBA is responsible for. Class 6 private roads, they have input on. And some communities, they are the regulators for excavation permits. Some communities, they serve as the building code of appeals. So you'd have to be understanding of that process and for that board and what those notification process are. Variances for the disabled. You need to understand that RSA, that there is a clause in the law that says that once the need for a variance granted for a disabled person is no longer needed, then that variance can go away. So if I had to have a, excuse me, if I had to have a handicap ramp on my house for my mother and she passed away, know that the law is that is not a permanent variance approval that runs with the land. So it's very important to make sure that it's a lot. Believe me, I know it's a lot of laws, it's a lot of nuances, but in order to make sure that you're not getting, appealed and that you're meeting the requirements of the law, that you understand that how many different applications are with each type of board. So, along those lines, there's a brief giving just some information because I hear these terms a lot. They get kind of muddled around because they sound alike and it's confusing. I'm not saying that it's not. But again, we need to be really specific when we're talking about particular applications because of their noticing and because of their appeals. So the ZBA is over here in the left lane, and they are in charge of special exceptions and variances, right? Those are the two most popular things. Planning board's over here on the right, right? And they're in charge of site plan subdivision. Okay, so those are the basic ones. We all understand that. But understand that what a special exception is within the law and whatever your zoning ordinance says. You should have your criteria for a special exception in your zoning ordinance. And it's, again, a special exception is a use that's allowed, but we have more criteria that you have to meet. Maybe it's an aquifer conservation district where you can still allow, a use, maybe a drive-through or something like that. Maybe not the best example, but if that use is allowed in the zone, it still needs a special exception. So you have to meet that criteria. They have to meet all the criteria. If they don't meet all the criteria of the special exception, then they can't be approved. So a special exception is something that's allowed through the zoning board with particular criteria that they have to meet. They have to meet all of them. Variance, I want the zoning board of adjustment to break the rules for me because I want to put a merry-go-round on my front lawn and have an amusement park. Okay. So I want to break the rules and I want ZBA to do it for me. And I'm going to plead my case to the ZBA. I have to meet 5 criteria as outlined in 674-33-1. If I can't meet them, then I should be denied. So ZBAs are pretty cut and dry with their types of applications. Now, to make it a little bit more confusing, you have to keep straight what a special use permit is, or they're also known as a conditional use permit. So again, a special use permit is something that's in the zoning ordinance, but it's administered by the planning board. So again, it's something where, maybe a special use permit is needed for a shared driveway or for working in a wetlands conservation district or working in a floodplain district where that I'm allowed to have a driveway. But I want to have, this is a 2 driveways for one lot, or I'm allowed to build in a floodplain, but it depends where and what, and you have to follow these types of things. So those are what a special use permit is. And even though they're in the zoning ordinance, the authority is granted with the planning board. And so why we have to keep applications straight in this, if I want to appeal a special use permit, that was granted by the planning board, even though it's in the zoning ordinance, even though it's the planning board interpretation of the zoning ordinance or working with it, I don't appeal that to the ZBA. I appeal that to the Superior Court as outlined in 677-15. So it's really important to work with your town attorney, understand different types of applications, understand their appeal processes and what kinds of appeals for each application. So application is deadline day, okay, application management. I learned the hard way once that to not accept applications for planning board or zoning board or anything at 4:29 p.m., right? Don't want to deal with that. So at the beginning of the year, when I would do my meeting schedule and it was on all the applications and it was on all the meeting schedules for all the boards, is my deadline was at noon and I stuck to it. Now, if someone calls me and says, hey, Stephanie, I'm going to be 20 minutes late. Okay, I'll allow that. If I know that someone's going to be late, or I'm working with that applicant so they can get all the materials in, but they have extenuating circumstances, I'll work with people. But 4:29 in the afternoon drop off of a planning board application that's this big, it's not fair. So stick to your deadlines, work with your deadlines, speak with your chairs if necessary of your boards to say, hey, this is to prevent people from coming in at the end of the day. That way during the day, I have enough time to give it the preliminary review to make sure they have their owner permission slip, they've signed the application. It gives me an opportunity to, have time to make sure that things are set. I can still call them and say, hey, you forgot your check. Hey, so-and-so didn't sign this, and still have them bring in the information. But don't let people drop off an application at 4:29 on deadline day. Create a spreadsheet, make sure all your applications are up to date, all the escrow accounts are up to date. It's, you're dealing with a lot of applications and a lot of different boards and a lot of different stages. So make sure that you have some type of tracking system to keep track of it. It's really helpful for town report and year-end reports as well, to know how many applications you've had and where everybody's money is and what part of the approval process they're in, what you're waiting for, what documents are coming through. So along those lines, I would create a cover sheet for each application, and when they went to TRC, when they were submitted, what's their next stage. That way, if I'm not in the office or an applicant the public wants to look at it, look at the file, it's pretty up to date so they can understand where the application is in the process. Is it approved? Are we waiting for more information? And when I used to, staff have 5 night meetings a month working for 4 boards, it was really helpful for me to just pick up a file and look at the cover sheet and know where this application was and what's its status. Another thing, don't confirm and verify butters for applicants. In my opinion, I would help them and maybe identify them on the map. But as the law says, it's their responsibility to verify butters, and they verify butters based on the town's tax map information, or excuse me, tax card information, where the tax bills go, or is the official address. So I just would not leave myself open to, oh, well, the town, land use administrator told me this was in a butter, when a case gets approved. And so I never wanted to go down that road. Review with your town attorney, whatever is comfortable. They have to defend you guys in court, right? Or defend the towns in court and defend board actions and things in court. But I just wouldn't make it a practice. I would certainly help them on the tax maps and show them. I would certainly recommend, hey, if you have a butter, one property over, like I said, but I could still say that this project is going to affect me. I would rather notice that person than have not noticed that person. And then they can say, hey, I should have been noticed. They could appeal, they could stop the process. So it just, when in doubt, spend the extra money, whatever it is for notification these days, and over notice, so that you're preventing any abutters or anybody feeling left out. And it's actually also, it's goodwill to over notice, especially if you're, applying for something that may be controversial or maybe, something big in town. It just spreads goodwill. So I would recommend, you stick with, a little bit of over noticing. And also, I set a policy based on the number of abutters that I would be in charge of versus the applicant. And the first time that I got a telecommunication application, telecommunication ordinance or personal wire carrier ordinance application in, when you have regional notifications in addition to abutters, it was a lot. And it took me a long time. So I worked with my chairs, I worked with, town administration and said, listen, I think it's only fair to have the applicants, if you've got 10 or 20 or whatever number you're comfortable with of abutters, that the applicant prepare information and submit it to you with mailing addresses already done or labels or whatever the case is, because that's a lot of work. I've been there. I've done it, large applications, and to go through and be responsible for 30, 40, 50, preparing abutter notices. It takes a long time. So I picked a number, it was 10 and below. I would do the mailing labels and the envelopes and I would prepare all that, and 10, or 10 and above, or 11, the applicant would do it. Again, whatever your personal preference is, I think it's important that we're not overburdened with stuff that the applicant can do. Also, that includes making copies. Don't make copies of applications for applicants. That's, if they're missing one sheet of paper or something, sure. But don't be responsible to make 10, 12, 15, 8 complete copies of an application for an applicant when they can submit them. So on your deadline day, again, you're responsible for just doing a precursory review of the information. You're not reviewing whether the traffic study is complete or not, or you're just reviewing to make sure basically that checklist items are submitted, waivers are submitted if not, that the proper fees have been submitted. And then you build the file, right? You sign it the application number. Mostly it's the year and the number. So 2023-001, and then the tax map and lot number. That's the identification number that you should be using for your application, for your files. Once deadline time is passed, maybe the next day or something, make sure that you inform the chairs of, yes, we have applications. Yes, we have this many. You're still working on processing all the information you got in, processing your fees and your escrow accounts if those are applicable. Start making your templates, start doing create the public notice, the abutter notice for each application, the abutter notice for the public, and start working on preparing your packets and circulating the packets. That's all this, whatever administrative, procedures work for you, is what you should be doing, work them out, and what you should be doing for every application. Every application should have the public notice of public hearing, the abutter notice, minutes for that particular application from the meeting, so that when I look at that application in 10 years, I know what happened and I saw that they were noticed properly, all that kinds of stuff. It's building a file for history and for legal purposes if something is ever challenged. So the day before the meeting, or excuse me, 7 days before the meeting, make sure that all your members are going to attend. Now, I understand that stuff happens, but you want to make sure that you're checking in, make sure they receive their packet or give them their packet, a week before the meeting, and make sure that they're doing their homework. I understand in planning board meetings where they show up and they plop the packet on the table and they open up the envelope and they've had the packet a week and they didn't do their homework. I understand that. But you'd still just make it a practice if you can, as part of your procedures, to try and get them to do their homework. Finish preparing up your template for your minutes and for your decisions, which makes it much easier during the meeting and after the meeting if you already have your templates made up. And review the agenda with the chair. Again, the agendas can change within 24 hours of the meeting. So if someone comes in and wants to talk to the planning board about a certain topic, but what's not on an agenda that went out 4 days ago, you can amend that agenda, keep the chair up to date about what the meeting topics are. Again, day of the meeting, just make sure that you have a quorum. It's not having a quorum is really frustrating, and for those of us who've been through it, it's frustrating and expensive for the town and for the applicants and for the abutters. So getting confirmation of a quorum, and again, I understand circumstances can arise where you can't have a quorum, but make sure it's that you've confirmed one. Confirm that the applicants and agents are attending as well. You can take last minute continuations. You know, I've had a lot of those that someone emails me during the day, hey, we can't make it tonight. Okay, that's fine. Just make sure that you're updating, you know, the chair over that. And, you know, inform the chair of any changes to the application or to agenda items. The cleanup after the meeting, you know, your planning board or your zoning board hangover the next day, right? Just make sure that you're starting that clock and that you've got enough time to complete the minutes and the notices of decision. Make sure you're updating all the tracking sheets, cover sheets for applications. You know, begin issuing and finalizing your notice of decisions. Make sure you're giving that leeway that if your chair likes to, you know, review or has to sign notices of decision, make sure within that 5 days that you're accounting for that it's done, for when the last possible day that those decisions have to be issued. You can work with the applicants. You can remind them of what their conditions of approval are, then what they need to submit. Maybe they need to submit a DOT permit before you can get the plan signed. So it's spreading some goodwill and being helpful, because that's what we're supposed to be doing as well. Helpful through the applicants, you know, help the applicants through the process. So keeping in touch with them, keeping in touch with their agents about moving that project along to get final approval is very helpful. Make sure that you're updating your escrow accounts. And again, once that file is finalized, it's approved and it's moved on to building permit time, you know, then you update your file and update your cover sheet, make sure that you have everything, all the minutes from the hearings, all of the agendas, all the notices, all the reports, all the abutter information. That's a complete file, again, for history record keeping purposes and for legal purposes. If anything ever happens and something is challenged or appealed, then a complete file is really important, because Superior Court judges, New Hampshire Supreme Court judges, all they have when a case comes in front of them is the file. All they have is the record. They weren't at the meetings. So they're relying on your information. They're relying on the minutes, the notices of decision, town's regulations, all those things that they're relying on. So that's why I say, you know, there's, you know, you don't have to be verbatim. Sometimes you do. You have to go back and listen to the tapes in court cases, but you don't have to be verbatim for minutes. But also, you shouldn't be like, planning board met, they approved, so-and-so made the motion, and they adjourned. So kind of remember that this case goes to Supreme Court or it goes to Superior Court. The court wants to know what happened, and that's through the minutes and through the notice of decision. So just make sure that you're finding that fine line, your comfort level with how you should be handling minutes and appeals and their timeframes. And so additional resources for the land use administrator for any types of application processes or public hearing processes, you know, please reach out to the New Hampshire Municipal Association. Reach out to your regional planning commissions, especially if you have a development of regional impact that you're considering or you need help with. I mean, by law, they're required to be identified. So you make sure that you know that process. And don't forget that on our website, we have the planning and zoning board handbooks, as well as tests that you can take to test your knowledge. Those tests do come with options to have a certificate of completion or not. In order to receive a certificate of completion, you do have to give your email address, but we absolutely do not share emails. That's just merely for sending you a certificate. So this is my contact information. Again, feel free to contact me anytime you want about any questions from this webinar or other webinars. Check out our website again for webinar schedule and for recordings of previous webinars. And our webinar for August is myself and attorney Christine Fillmore Johnston from Drummond Woodsum. We are going to be talking about zoning amendment time. Again, you know, it's tons of fun, zoning amendment time, doing it in the summer, but it's important that you start the process, and we'll be doing that August 17th from 12 to 1. So having said that, we will move into question and answer time if we have any questions.
Yes, Stephanie, we have a couple in the chat. Do you want me to read them? Good. All right, the first one is from Sandwich Land Use. administrator, I assume. A butter list accuracy responsibility of applicant. When checking if I correct / add, if list challenged, does responsibility shift to the municipal office if it goes to appeal?
I would say my non-legal planner opinion is that if you alter a butter list that was submitted by an applicant, even if it's for accuracy and correctness, then I think you're kind of getting yourself a little bit on the hook for liability. But that would be, again, something to, I'm just a planner with tons of legal opinions, right? So I would definitely check out that kind of process with your town attorney and ask them, what happens if I do this? Because they're the ones that have to defend you, defend the municipality. So good question, because those are the types of nuances that can trip you up and get you into trouble. So it's a good question. I would lean towards, if I'm altering anything that's already been submitted, then I'm dipping my toe into liability.
All right, next one's about minutes. Oops, it's also from the same person. Write up day after the meeting, then circulate to each member individually for basic factual corrections. As new minute taker, need names, places to be accurate to post. For answers only to me. No inter-email chat amongst members. Public posting and distribution to members next day or two. OPD handbook states administrator can continue to work on minutes for next meeting approval.
Okay.
So I guess that describes the process of how they do minutes. And I guess the
Mhm.
question is in whether that's right or wrong.
Yeah, I mean, again, everything is a caveat with town attorney, but circulating minutes individually to the board members is a good way to prevent having a non-noticed meeting.
Or BCCing everybody.
You could
BCC.
BCC as well. Again, those are types of things that you need to be very clear on and to verify with your town attorney. As a new minute taker, need names, places to be accurate to post. Yeah, for answers only to me. No inter-email chat, correct, amongst members. That's correct. Public posting and distribution to members next day or two. If you're able to do that, yep. Yes, you can continue to work on minutes. Okay, so the nuance there is that I have to have minutes done within 5 days to be able to present to the public. So if someone comes in 14 days after a planning board meeting, and they want to see the minutes, then they need to have draft minutes available with explaining to them these are subject to change. The board is still in review. These are still in the review process. The board may have changes, but yes, you can still work on minutes. You can still take those board, again, depending on what your town attorney says, but what I would do is if my board members are commenting on the minutes, through one email to me, one board member says, here's my change. You got to keep those changes. Again, these are the things you need to clear up with your town attorney about changes being made in email, which those emails are now part of the minutes. So you can have draft documents as long as they're completed in 5 days. You can still work on those right up until when you get to the meeting, when you have all of the changes. And then the board should be discussing the changes at the meeting. So they should, submit a change to me, and then at the meeting, when they're approving minutes, they should be discussing what they've changed. So again, nuances are really important to understand and work out with your town attorney.
All right, the next one, I think that's to everybody, whether anyone has examples of a spreadsheet they use for tracking, application tracking, and for the cover sheet for applications. So if anybody does, feel free to share. You can send it to us. We can send it out with the follow-up email.
Yeah, that'd be great. And we're at some point in the fall, maybe in early 2024, we're going to be working on a land use administrator handbook, which will be a lot more in depth from what we've seen today. So if anybody has one of those spreadsheets, we'd be glad to incorporate them and tweak them, and we would utilize them in our land use administrator handbook.
Great. All right, next from Allison from Concord. Minutes available to public 5 business days or 5 calendar days.
The law says business. That's why you need to figure that out with your town attorney as far as, what the deadline is. So, I had received this question before where an office was closed on Fridays and someone wanted the minutes. And so you're getting into like a weird area just because the office is closed. It's still a business day. So that's 5 business days. Work that out with your town attorney. Make sure that you are aware of when that 5th business day is.
All right, next one is from Herb. What is meant by deadline day? And what is meant by escrow accounts when it comes to a ZBA?
What is the first part of that? Deadline day?
Deadline day, yes, in quotation marks.
Deadline date. So if you're having, like I used to set up my schedules for ZBA and for planning board. I do the whole calendar year at one time. Planning board meets on the 2nd and 4th Tuesday of the month. So my calendar would book already. This is when planning board meets. Same thing with ZBA. If ZBA meets the first Monday of the month, I would have my 2024 ZBA meeting schedule up. And then back up your days, your minimum days of what your deadline is, as that's your deadline day for ZBA.
That's for submitting an application, right? To the
Is
ZBA.
that's what I'm
or
assuming
planning
that's
board.
what he's asking, right, Herb?
I think so. I'm assuming here.
Yeah, what is meant by deadline day and what is meant by escrow accounts when it comes to ZBA? Okay, so so deadline day, that's my little deadline day. But yeah, noon, deadline on your schedule of meetings. Don't let agents and applicants come in at 4:29 in the afternoon and plop an application on your desk that you have to process that day because it's the deadline day. Don't do that. You say application deadline is at noon. Some ZBAs may or may not have an escrow account. Well, and mostly planning boards should, but if you're getting into a ZBA situation where maybe you're doing a third-party review and that applicant by law is required to pay for the third-party review. That's the beauty of third-party review. That's why all, planning and zoning boards should be using third-party review, because it is someone acting on behalf of protecting the interests of the town. And it's paid for by the applicant by law. So if my car wash example, right, ZBA, meets and they said, listen, we're going to do a third party review. So we're going to continue this. So you have to submit, $2,000 to us because we're going to hire an engineer that's going to review the car wash application for special exception criteria. So that money comes into the town. I, as the land use administrator, then set up an account with finance. And I pay the engineer when they review the application. So escrow accounts for ZBA can happen, but they're more popular with planning board. So I hope that answers
Next
that
one
for you.
is the tricky one. What does verified mail mean?
Yeah, I have no idea.
Well, here's the definition in Google. Any method of mailing that is offered by the United States Postal Service or private delivery service that provides evidence of mailing.
Yeah.
So it's something that you have evidence that you mailed it on that date.
Right. And I don't know if you can, honestly, because I have not done it for 5-6 years, and I believe that's when kind of there was a little change to the law that was made during that time. Maybe it was a little bit before that, but I still did stuff old school way. So, check with your town attorney, check with your post office, check with your postage machine. Maybe there's a way that you can do a printout or something, or email. Something for verified, but those are the types of things you need to check out with your town attorney for what constitutes verified. And again, a lot of these things need to be in your procedures because board's rules of procedures, like, you can pull up many cases in New Hampshire Supreme Court that board's regulations and rules of procedures play a role in court proceedings. So just keep that in mind when we're going through all these laws, that your rules of procedure are meeting the laws and understand what that means. And verified mail is a good example. What's verified? We have a generic definition, but what does that mean when it comes to noticing the public and for notification purposes?
All right. So next one is from Allison. She's saying that she has a form, of an example for a spreadsheet that they use for a cover
Oh,
sheet.
great.
But if she could send it to us, Allison, we would share it with everybody who's on the webinar.
Sure.
Again, one from Herb. Does RSA 676:5 apply to a variance, special exception, etc. applications, or is this RSA section specific to appeals of administrative decisions?
Let me go back to that, to 676.5. Six 676.5 applied to variance special section, or is this appeals of administrative decision? It includes to read 676.5, and just for time's sake, and Herb, you can reach out to me if you want to discuss this, in more detail. But 676.5 appeals to the Board of Adjustment, Roman numeral 1, appeals to the Board of Adjustment concerning any matter within the board's powers as set forth in 674.33. So if you go back to wherever I had 674.33, you would see that appeals are.
Oh, you just missed. Oh, no, that.
Oh, here we go, right here. Yep. So 674.33, there's a link to that. I mean, all the slides, is that's the powers of the zoning board and adjustment, and it goes through administrative appeals, request for rehearing. So 676.5 applies, for appeals of administrative decision as well.
All right, so next one is for file retention. Are digital files becoming recognized as sufficient? And are digital submissions of applications acceptable, or is that addressed in rules of procedure?
Digital files become, I would have to say, because when I left municipal planning to come to state planning, we kind of was just on that cusp of digitizing files, and I understand that because town halls are running out of space, and buildings, town hall buildings. I've been in 2 town halls where we've had to relocate the planning and land use department, and relocate files because the building couldn't handle the weight, literally, of the files. So digitizing, I believe, without being, again, your town attorney, but yeah, as long as there's a way to keep those files and keep them, forever, or for whatever, you decide is, the minimum standards to meet the law, and for that, and review with your town attorney. But I would consider digital file retention, becoming the wave. It already is the wave of the future. That does count for, retention of files. Digital submissions of applications, there's communities that do it. There's communities that have, the planning board applications right online. That, I was old school submission, at the time when I was in municipal planning and worked for municipalities that didn't have that ability to do that. I think maybe you'd see that in some of your cities. I think actually Manchester, just off the top of my head, I seem to remember being able to get online to look at their applications, which is very convenient, but I have no idea how a municipality would go about, getting that done. And that's something that you should, be able to, again, check with your town attorney. How do you deal with the acceptance of electronic applications if you want to?
All right, so someone's asking, Carrie is asking if there's a possibility to do a specific to shoreland, wetland, water management RSA's course. So that's a little outside of our today's webinar, but we will add that to our list of future trainings.
Sure, we'll take your chat question, and we'll add that in, so we have that on record now, and so we'll put that into the rotation. We have a few scheduled up for the rest of the year, but we'll definitely appreciate the suggestion, and we'll take that into consideration for a topic. Thank you for doing that.
Then Judy, City of Franklin charges $10 per abutter to cover processing and costs of certified mailing. We get a verified signature pickup. That's just describing their process. Then someone says they're always using certified mail, which is the practice still standard. And then verified could use FedEx or DHL delivery for a butter letters, etc.
Mhm.
And that's all we got for questions
Okay, yep.
so far.
Way to go, Franklin. I mean, you know, like I said, I'm kind of old school. Because, you know, all it takes is that one case, that one application where, you know, someone complains that they weren't noticed, and our responsibility is just prove that we mail it, and what happens after the, you know, the post office, if they crumple it or it gets, you know, misplaced. The municipal responsibility is to have proof of notification, proof that it was sent. Some communities that I went to even went above and beyond that and did the return receipt requested with the signature cards. So again, things to talk about with your town attorney and your chairs, things whether or not to include in your rules of procedure about how, you know, what the costs are. We have to post our fees. So, you know, online, the law requires that all fees are posted, and that would include application fees and butter fees and things like that. But I'm old school that way, and I would rather have, you know, that proof that someone signed for it. Yes, that I received it, and then later on try and have them come back and say, I never received it, but you know, they did. So have a good conversation, a long conversation with your town attorney. It's really important that you learn from them and that they understand where you're coming from, and work on updating your rules of procedure, and work with your chairs about it. Yep, and using certified mail, you can get receipts, absolutely. Verified could include FedEx or DHL. Okay, yep, that's true. Yes, it could. So, you know, make sure those deadline days, you work them out on your schedule. That you know, start working with your chairs, put it in your rules of procedure, put it on the applications, that you're all want noon deadlines. And go, you know, one of the things that I found helpful when I would prepare, you know, get my templates in order and get the minutes template together and get all that, is that it was really helpful on that next day when you have that planning board, zoning board meeting hangover, that, you know, being up late and having a lot to do and it's a long day, you have that feeling the next day that, well, at least some of your things you've already started it. So it makes it a little bit easier. So, I hope that everyone enjoyed today's webinar. Thank you very much for joining us. I see we've gone over, so that's, you know, appreciate your extra time. Be interested in any other templates that you may have, you know, forward them our way and we can review them and see if we can utilize them in our land use administrator handbook. And again, feel free to reach out to me anytime that you'd like with any kind of procedural questions. And again, make sure that you're in communication with your town attorney. Do we have a last question? Somebody just pop in. Oh,
No, that was just me posting our
great.
webinar feedback form.
Again, thank you very much for attending, everyone. And don't forget our August plan webinar it's zoning amendment time. And so we'll see you then. Thank you very much.
Thanks, everybody. Bye.